Hello and welcome to a new episode of Legal Wrangle on Corporate Laws. We have selected three important rulings given by Supreme Court of India. Let's begin with the first case. In this case, the issue was whether an appellate authority can impose a condition to deposit certain amount as a condition precedent for hearing the appeal, even though statute doesn't impose such a condition.
The appellant is a partnership firm engaged in the business of transportation of coal and sand. In June 2014, the appellant participated in two tenders floated by the Western Coalfields Limited. Though it was not the lowest bidder, but it was served a show cause notice by the Competition Commission of India, alleging that the appellant firm was involved in anti-competitive and unfair trade practices in collusion with 9 other firms. After considering the reply of the appellant, CCI ordered inquiry where the DG concluded that the appellant had indulged in anti-competitive practices. The Commission imposed penalty of Rs 3,61 lakhs. The appellant filed the appeal before the NCLAT, which granted stay on the condition that appellant would deposit 10% of the penalty amount. The appellant defaulted on the ground of financial hardships. More time was granted, but it failed again and its petition was rejected.
The Supreme Court allowed the appeal and the matter was restored to the NCLAT for deciding the case on merit. The court held that the appellate authority cannot impose a condition to deposit certain amount as a condition precedent for hearing the appeal when statute does not impose any such condition.
Here are the key takeaways. Firstly, the provisions under the statute does not impose any condition of pre-deposit for entertaining the appeal. Secondly, right to file the appeal and have the same decided on merit. If it is filed within the period of limitation is conferred by the statute, and that cannot be taken away by imposing the condition of pre-deposit. In a nutshell, the Apex Court held that the dismissal of the appellant's appeal for non-deposit of 10% of penalty is beyond the intent of the legislation.
In this case, the issue was whether the dispute on the question of seat and venue under the International Commercial Arbitration Agreement is a fit case to be referred to the larger bench.
An award was pronounced in favor of the respondent foreign company in an international commercial arbitration proceeding against the appellant Union of India. The appellant filed an appeal before the High Court under Section 34 of the Arbitration and Conciliation Act, wherein the appellant had challenged the legality, validity and correctness of the award. However, the respondent contested that the Indian courts had no jurisdiction to entertain the appellant's application. The single judge upheld the respondent's preliminary objection and held that keeping in view the terms of the agreement in question coupled with the law laid down by the court in several decisions governing the issue arising in the case, Indian courts had no jurisdiction to entertain the application.
The Apex Court held that the dispute on the question of seat and venue under the International Commercial Arbitration Agreement is a fit case to be referred to the larger bench. The Apex Court held that it was a fit case to exercise the power under Order 6 Rule 2 of the Supreme Court Rules 2013 and refer the case to be dealt by the larger bench. Now let's move on to our third case, which pertains to the Smugglers and Foreign Exchange Manipulators Act 1976. The key issue was whether in the absence of sufficient cause in filling the appeals beyond the period of limitation, the appeal warrants dismissal. Let's first understand the factual matrix. An order was passed against the appellant under Section 7 of Smugglers and Foreign Exchange Manipulators Act in respect of some property. The appellant filed an appeal under Section 12(4) of the Act before the appellate tribunal. However, the appeal was filed beyond the condonable delay of 60 days. Accordingly, the tribunal dismissed the appeal. It was held by the tribunal that there was no reason to condone the delay in filing appeal, besides it had no authority to do so. The High Court also validated the view of the tribunal.
On appeal, the Apex Court held that appellate tribunal doesn't have power to condone the delay beyond 60 days. Here are the key takeaways. First, the issue regarding manner of service of the original orders or whether such service was in accordance with procedure under Section 22 of the Act was immaterial. Second, it was also not necessary to delve into whether or not service of order upon the appellant's lawyer was proper or whether service of order upon the appellant's minor daughter was as per procedure prescribed under Section 22. Third, if the appellants knew of the order passed against them pursuant to which appeals were filed, then the irregularity in manner of service is inconsequential and could not be termed as illegal. Hence, the Tribunal and the High Court's orders merit no interference.
The Apex Court held that in the absence of sufficient cause in filing the appeals beyond the period of limitation, the appeal warrants outright dismissal. With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube for more such episodes. Please send in your suggestions at editor@tiol.in. Thank you for watching. Goodbye.